Hello and welcome to Sport and Recreation Law. Today I want to talk to you about law in Australia generally and also law as it applies to the fitness instructor working in a health and fitness centre. Okay, first thing I want to look at is law generally as it applies to Australia wide and the divisions of law that exist within Australia. Okay, law in Australia is known as common law. That basically represents the legal system of Australia, which is derived from the English model of law. Common law has two main divisions, criminal and civil. Let's look at somebody driving a motor vehicle. Somebody driving a motor vehicle under the influence of drugs or under the influence of alcohol has an accident which causes damage to community resources or injury to another person. They can be tried in the criminal court system because they have committed a crime. They have driven a vehicle under the influence of drugs or alcohol. Alternatively, somebody's driving a motor vehicle and a tyre blows out or something causes the vehicle or loss of control to the vehicle, results in the same thing, damage to community resources as well as injury to another person. Now that person has not necessarily committed a crime, but they may have injured somebody in the process. Now that person who's been injured in this motor vehicle accident, the third party, or the innocent person in this incident, could seek compensation for their injuries through the civil court, or the civil court system of Australia. And what's the division of law in the civil court? Is known as the law of torts. Now tort, quite simply, is a French word meaning a wrong. So the civil court allows compensation, or people to seek compensation, if they feel they've been wronged in any way. Contracts are a good example. People who believe they've been wronged by a contractual dispute can seek compensation through the civil court for that tort. However, the most common one and the most relevant one to us is the tort of negligence. What is negligence? Negligence by definition is an act or an omission of an act that led to harm. So now let's look at the fitness instructor example. Let's say a fitness instructor is working on the gym floor, a client approaches them and they want an exercise program. The client has no exercise background, hasn't exercised for a long period of time and has never done any weight training in their lives. This fitness instructor prescribes a very high intense, high voluminous training session which ultimately led to harm because this novice trainer or this beginner level trainer wasn't used to such exercise formats, and by doing such a high load led to injury. That person, that client, can seek compensation for their injuries through the civil court for the tort of negligence. Also, as mentioned, negligence by definition is an omission of an act. Therefore, let's say a fitness instructor working on the gym floor sees a person performing the squat exercise but performing it incorrectly, putting a lot of stress on their lower back. The fitness instructor decides to do some other duties before addressing this issue, and during that time the fitness instructor or the client performing the exercise has injured their lower back. That client can also seek compensation for their injury through the civil court for the tort of negligence because that fitness instructor failed to do something that they should have done. That is, they omitted an act which led to harm. Okay, just going one step backwards, talked about the division of courts or division of law in Australia. We've talked about the most common tort, the tort of negligence. But somebody cannot face a negligence case unless a duty of care is owed. A duty of care depends on establishing some sort of relationship between the parties. And as I've written down, a professional relationship. Let's say you're at a cafe having a meal. You see a lady walk in, you notice the floor is uneven and very wet and slippery. The lady's wearing high heels, and you think to yourself, that lady's going to hurt themselves or fall if they walk on this slippery, uneven surface. Sure enough, the lady does. That lady cannot take or cannot seek compensation against you for the tort of negligence because you do not owe that lady a duty of care. However, that lady can seek compensation for the tort of negligence from the business owner, because it is expected that the business owner provides a safe environment for their customers, and there is a professional relationship between the business owner and the customers, therefore a duty of care is owed. Now, most important for us, yes, as a fitness instructor, a duty of care is owed to all of your clients. A professional relationship exists, therefore you owe a standard of care to be provided to all of your client groups. Okay, let's say a fitness instructor is facing a claim of negligence. This is the criteria that will be assessed during their case. Number one, what a reasonable person would have done, or what a reasonable person would do in the exact same circumstances. The judge will assess what is reasonably expected for that level of service. So the judge will ask him or herself, if a fitness instructor saw a beginner level client, is it reasonable to expect that a fitness instructor should know the difference between a beginner level client and an advanced trainer? Should the fitness instructor know the difference between beginner level exercise prescription and advanced exercise prescription? If the answer is yes, then the judge may make a decision that it would be reasonable to expect that the fitness instructor knows the difference between exercise for a beginner and exercise for an advanced person. So in the example before, where the fitness instructor prescribed really high intensity, high volume training for a beginner level participant, the judge may assume, and I would assume so, that he or she would see that as an act of negligence. The other example we used was the squat example. The fitness instructor not intervening and correcting the exercise format, which led to injury to the lower back. Is it reasonable to expect that a fitness instructor should know the correct performance of the squat? And is it reasonable to expect that a fitness instructor should intervene when they see somebody performing the exercise incorrectly and putting themselves at risk for injury? Again, in that circumstance, it would be expected for the judge to assume that that would be reasonable for a fitness instructor to do. Therefore, that instructor will likely be facing compensation claims for negligence. Other factors, age. Generally speaking, the younger the participants, the higher the standard of care that's required, or the higher the duty of care that is required. Qualifications is next. The more qualified you are as a person, the higher the standard of care that's going to be expected. Now that you've got your Certificate 3 Fitness, or very soon to have your Certificate 3 Fitness, it would be expected that you provide a high standard of care with that additional qualification. Activity. The more dangerous the activity, or the more potential risk involved in an activity, the greater the standard of care, or the greater a duty of care that is owed. For example, base jumping and parachuting are going to require a high standard of care as opposed to something like chess or table tennis. Skill level. Mentioned this before. Beginner level athletes or beginner level exercise participants will require a higher standard of care than more advanced exercise participants. And special populations. For example, people with intellectual or physical disabilities, or people with lifestyle related conditions such as high blood pressure, diabetes or obesity will require a higher standard of care in your service provision. Okay, I want to talk a little bit about insurance now. First point I've got there is professional indemnity insurance. Professional indemnity insurance provides financial protection for the tort of negligence, for the advice that you give or the advice that you fail to give but should have. As you can imagine, as a fitness instructor, that is a must policy, because by and large the bulk of your duties is giving advice on how to help people achieve their exercise goals. It is my biggest recommendation that as a fitness instructor you have professional indemnity insurance. Now, as mentioned, professional indemnity insurance provides financial protection. It does not provide legal protection. So a lot of people get into the trap of thinking, I've got insurance, I don't have to worry about risk, because if something goes wrong, I've got appropriate insurance coverage, I've got appropriate protection. The reality is, insurance is used when something goes wrong. And sometimes in life things will go wrong, and you do have financial protection in the case that it may happen. However, don't get into the trap of assuming that you've controlled all the risks, or all the risks that you're likely to have exposure to, because you've got insurance. It is just financial protection. It does not offer legal protection whatsoever. Now, it is a requirement of the Fitness Industry Code of Practice that all fitness instructors who are working in gym and health centres do have registration with Fitness Australia. It allows the fitness industry, or allows consumer confidence in the people that utilise the services of the fitness industry. Therefore, additionally, as well as registration with Fitness Australia and complying with the Code of Practice, you also, as part of your fees, get professional indemnity insurance as part of that. Therefore, you need to be registered with Fitness Australia from a Code of Practice point of view, and also to provide yourself some financial protection as well. Another point with professional indemnity insurance is that once you have your policy, consult a broker. If Fitness Australia are providing your policy through their registration fees, talk to a broker or a business consultant and say, these are my duties, these are my roles, this is what I'm likely to do in the industry, these are the client groups that I'm likely to have exposure to. Is this policy adequate to protect me financially? You may find that you may need additional coverage. Next point I've got there is legal expenses. It's also important to check with your broker that your policy does also include legal expenses. Because the last thing you want to happen is to face a negligence case, successfully defend it so you don't have to use your insurance policy, but find out that it's cost you so much money in defending the claim that have been used for legal expenses in defending that claim. And therefore you might find that you're out of pocket because your insurance policy does not provide coverage for the legal expenses incurred in administrating cases of negligence. So that's something to check with the policy and also with your insurance broker. Additionally, one point that's not there but it's relevant is that in the Australian law system, people have up to 3 years to lodge a claim for compensation. So somebody could injure themselves, or let's say the person doing the squats injuring their lower back, somebody could injure themselves without you even knowing it, then 3 years later lodge a claim for compensation against you because you failed to give the appropriate exercise advice. Make sure that your policy allows coverage for that period of time of 3 years, which allows the client to make compensation against you. That is, make sure the policy offers that full protection and that it doesn't cease when your employment ceases or when your roles as a fitness instructor cease. It actually covers you for that 3-year period, for that time that you worked as a fitness instructor. Okay, waivers and disclaimers. Waivers and disclaimers are what people sign when they start a gym. They basically say, basically the waivers and disclaimers allow the person to say, I've given all the information that I think is relevant, I've been completely advised of what's going to happen, I know there's a risk from exercise participation, all my questions have been adequately answered, if anything happens to me, I'm not going to take legal action, I'm not going to seek compensation. Now, waivers and disclaimers do offer some form of legal protection, and they have shown that in the past. However, they do not nullify the law or the tort of negligence. That is, if a person signs a waiver or disclaimer which says, I'm not going to take any legal action in case something, in the event that I hurt myself, if that person hurts themselves because of a negligent act of a staff member or an instructor, they can still seek legal advice and still seek compensation for that, despite saying that they wouldn't. It does not nullify the law of negligence. It does offer some legal protection, but does not nullify the law of negligence. Therefore, they shouldn't be seen as these documents that are a substitute for an appropriate risk management process. However, they are a wonderful tool to warn people of the inherent risk of participation in exercise. And participation in exercise does carry a risk. Yes, you have great health and well-being outcomes, but you are putting stress on your body, and as much as practically possible, the health and fitness centres try to alleviate that risk by doing pre-exercise questionnaires, fitness assessments, seeking medical approval where needed to try and alleviate that risk, but it cannot be completely eliminated. It can only be minimised. Therefore, waivers and disclaimers are a good option or a good opportunity to allow you to advise your clients that even though you're going to do everything as practically possible to minimise the likelihood of you hurting yourself, there is still a possibility that that may happen. Okay, the next slide, or the next two slides, talks about the coach's legal requirements. Now the reason why I put this in is because to date, Fitness Australia haven't come out and said these are the legal requirements or the legal standards of conduct that we expect from our fitness instructors. However, the Australian Coaching Council, through their Level Low, Level 1, Level 2, Level 3 coaching certificates, have come out and said these are the 10 legal requirements we expect of all of our coaches. And as you can expect, coach and fitness instructor are similar roles. Therefore, the next 10 points provide a very good framework to you to make sure that you're providing a safe environment for your clients, minimising the likelihood of risks, and therefore minimising the likelihood of compensation being sought against you. Number one, provide a safe environment. That includes arriving early to your shift, inspecting the exercise environment, making sure that it's safe and operable for clients to use. Plan activities. If you're going to run a circuit class, if you're going to run a group exercise class or a one-on-one personal training session, thoroughly plan your activity prior to conducting it. Any issues that may come up, it'd be great to identify them beforehand than rather have them present themselves during the activity, causing potential risk. Injury evaluation. Screen your clients. Health and fitness centres do this, as mentioned, with pre-exercise questionnaires, with fitness assessment, and sometimes through waivers and disclaimers, as well as seeking medical clearance. But it's also good just to ask people prior to exercise participation, how are you going? Is there anything wrong? Is there something that I need to be aware of before we start exercising so that I can modify it as necessary? Mismatch. More of a sport-specific one. Basically in a sporting context, it means not having very big strong athletes competing against smaller, not as strong athletes, or not getting a really tall person and putting them in the front row of a rugby scrum. Safe equipment goes hand in hand with safe environment, making sure that equipment is safe and operable, inspect it prior to use, and make sure that maintenance procedures for equipment are followed, addressed and signed off on. Inherent risk. Yes, there is a risk from exercise participation, and your clients need to be advised of that. Supervision. Make sure all activities that are under your supervision are adequately supervised. Look at your supervision models. Through your work as a fitness instructor, can you supervise everybody at some stage on the gym floor? First aid. Part of this course requires first aid qualifications and first aid training. Keeping your qualifications relevant and up to date, and knowing and having access to first aid resources on the job. Rules and conduct. Again, a bit more of a sports coaching theme. Rules, making people aware of the rules of sports participation, but also rules of conduct. In the fitness industry, we can use this in developing rules to make a safer environment. For example, clients using towels on exercise equipment to prevent the risk of spreading biological hazards through bodily fluids such as sweat and blood. And record keeping. If there is an incident or if there is a near miss, documenting that with the date and time and exact details of what happened. Therefore, if there's any need for that information to be sought in the future, having written hard copy evidence provides very strong evidence if that is required for a law of court. And the final thought, what I just wanted to finish on was talking about client safety and welfare. I know in these classes or in this information being covered, it can come across as quite negative. Talking about what risks are, what could go wrong, how we live in this litigious society where people are seeking compensation for various torts and various wrongs. And by and large that's true. But what your frame of mind needs to be is your client's safety and welfare. That is, making sure they provide a very safe environment because you want to have a wonderful exercise experience, clients that speak very highly of you, and clients that keep coming back for more. If that's your first priority, risk management will take care of itself, because you'll be in tune to these potential risks and you will know what to do to minimise that, to ensure your client's safety, their enjoyment and their goals being met. Thank you for your time and good luck with your study.